Is the VP of Product at LexisNexis. He's a graduate of this law school, graduated in 2012. And I remember, I think it was maybe in your 3L year that you started to think about Ravel. Really based on his dissatisfaction with the available research technologies at the time. Daniel said there must be a better way to do legal research, and in the typical Stanford student fashion, he very quickly started a company which he got funded, and built one of the trailblazing companies really in the big what we call big data law space, and together with his co-founder. Nick built this company. It was acquired, I think, in 2017 by LexisNexis, and he took on the role of VP of Product at Lexis there. So it's really wonderful to have Daniel here with us today. He's really one of the leading entrepreneurs and visionaries in this space who really knows how the practice of law will change through these data analytics technologies, and he's here with us today to enlighten us about this. So it's really wonderful to have you here. Big thank you to LexisNexis. Lexis has been a supporter of our center for several years, and they're sponsoring this lunch here today. So big thank you. To Lexis, and especially Harvey Meza, who's the Lexis Stanford person, and director of the Stanford relationship with Lexis. And so yeah, thank you Lexis, and thank you Daniel. Please join me in welcoming Daniel Lewis.
Hi, thanks. That was a great intro. Thank you, Roland. So I figured I could give a bit of background around my story and the Ravel story and how I ended up here from where I was in your chairs 10 years ago. And then I could talk about some of the substance of what's going on with legal technology and AI and analytics. And then I'll take questions. So I graduated in 2012, like Roland said, and I started thinking about legal tech in my 2L year. I had come into Stanford thinking I was going to do something in clean tech. I'd worked at a think tank before law school in DC doing energy policy. And so I thought I was going to come out here, find a role at a clean tech company, and that was what I wanted to do. And along the way I got distracted by the research tools we had to use because they seemed pretty similar to what I'd seen my parents using years earlier. And so I started reaching out to professors in the computer science department asking whether they'd ever done any research or built anything in the legal space with legal information. And they pointed me in the direction of a couple interesting papers, and I started connecting with postdocs and master's students in their classes, and put together a vision along with a classmate, Nick, who's another Stanford student, around what we thought a better approach to legal research could look like. And it included data visualization as a way to understand the relationships between cases, as well as a more data-driven approach in general to think about what was likely to happen in cases and in front of particular judges. So we built a business plan in one of the entrepreneurship courses offered at the law school, and then we entered that business plan in the Stanford University-wide business plan competition basis. And we ended up finishing second to a team from the med school that was curing kidney stones. We felt pretty good about that. And we took a class at the D.school, which if you haven't heard is a really awesome organization with a little past professor there. It's an interdisciplinary graduate level institute that helps in large part to say, how do you build something and prototype it really quickly? So we had this idea, and it was floating around in our heads, and taking that course over the period of about 10 weeks, we were able to build a functioning prototype. And that coincided with coming in second in the business plan competition. And we met an investor who had a JD from one of the big venture firms on Sand Hill who said, hey, I've been able to watch your guys' progress over the last few months, and you should come in and talk funding. So this was happening in May of 3L year. And we went and talked with him. He said, I love your guys' idea. Come back and talk with my partner on Monday. We came back, talked with his partner, and got a phone call a few hours later saying, hey, we want to invest. We'll put in $500,000. We'll help you raise the rest of the round you guys need. So we spent that period through graduation, through studying for the bar, raising money from other funds. And fortunately pulled both things off successfully. Was able to pass the bar, was able to raise money. And then we started the company in August and hired about 5 people. We'd raised a little over $1 million at that point. Hired a team of 5, started building out a better prototype, started putting it out in front of the students primarily and attorneys at firms to get feedback. Made good progress. About a year later, we went back and raised another $8 million. We built out a sales team, started selling it to law firms where we had pretty good traction at big law firms around the country. Started building a school program where we had students using it around the country. Raised another $6 million a year or 2 later, and then got acquired by Lexis in 2017. So since then, we focused on integrating all of our products into Lexis. So if you use Lexis, you may have seen some of these. One is called the Ravel view. It's a toggle within the search system now, so you can go from a traditional list to this visual view. The other main product is called Context, which is analytics about judges, expert witnesses, courts, and we've just launched company analytics. We're launching law firms and attorney analytics this year. So I can walk through what those mean, but if you've used them, or I encourage you to check them out, they're pretty neat, if I do say so. So that's the journey. Within Lexis, I actually have just taken on a new role. I'm now responsible for practical guidance, so I can touch on that too, but that's all of the example documents, all of the standard forms, and all of the treatises and practice guides that Lexis has. So kind of a new space that's been very traditional and trying to think through what can software do and what can analytical kind of data-driven tools do in providing people with really practical guidance about how to practice law. So I wanted to touch on just a few broad topics that hopefully can then spark a conversation and questions. So one of the interesting things to me is the conversation about what legal tech can do in the law is no longer what will it do 5 years from now or 10 years from now. It really is about what is it doing today? What is it already doing that's impacting how lawyers are practicing law? And so this is the kind of question that was pretty unanswerable 10 years ago and is answerable today. How long will this case take to make it to trial? This is another kind of question that was pretty unanswerable 10 years ago and it's answerable today. What cases and language is my judge most likely to cite when ruling on this kind of decision? This is an attorney at Wilson Sonsini just down the road here in California who's been using Lex Machina, another Stanford spin-out product, and Ravel over the last few years, and talking about how it's really changed his practice in how they make decisions and changing the broader profession from his vantage point. And this is why. So one of the examples of what we can do with analytics now is understand how judges are ruling on particular types of motions. And we can be pretty granular about that, so it's not just in general, but in particular topics for particular kinds of cases. And one of the things that we found when we launched these a few years ago was that because nobody had ever seen these before, there was a lot of new things to explore. So what we found, for example, was if you look at the Southern District of New York, and this pattern holds true in every district that we've looked at, and you compare judges, the active judges, just on one motion type, for example. So here, a motion to dismiss, the grant rate. You say, how often are these individual judges granting this kind of motion in general? And you can see a pretty wide spread, right? So at the far end, you see judges who are granting these more than 70% of the time, and at the low end, judges who are granting them just 40% of the time, and everything in between. Which is pretty remarkable, I think. I would not necessarily have guessed that there's that much variation between judges in the same district on the same kind of motion. And what people are now using this information to do is make better decisions about what's likely to happen given an individual judge. They're using it to pick forums and choose where to file lawsuits in the first place. And they're using this to dig into an individual judge's decisions on a particular motion type and help change their minds. So we've had firms talk about how they they argued for a particular motion in front of a judge who said, no, I never grant that sort of thing. And the parties were able to surface actual cases and decisions that the judge had made in the way that they wanted to that judge to get them to change their mind, say, oh yeah, I do have some precedent here that I've forgotten. So it's really exposing some new details about decision making that previously people just didn't know, or it took an army of attorneys to try to figure out through manual research. The other interesting thing we've seen is variation between motion types, right? So if you took a motion to dismiss nationally, the grant rate is around 60–65%. And you can compare that to other types of motions, right? So if you looked at another kind of top 10 motion, a motion for injunctive relief, you'd see that those are granted just 25% of the time. And each motion has its norms and standards based on how difficult it is supposed to be to win that kind of motion. You can see that play out in the analytics and the stats. This is another example of the kinds of thing that you can do. So I mentioned this is one of the things you can do in context, but you can look up an individual judge, so Judge Seaborg here in San Francisco, and you can see what cases he commonly cites to when ruling on a particular kind of motion. And we can show you specific language that he's used again and again, essentially copying and pasting in between decisions as he frames a standard and frames a rule. And we know that clerks are using this. Like clerks work for Seaborg, and they will use these tools to find past precedent and find those decisions so that they can write decisions, new decisions, in the voice of that judge. So firms are taking advantage of this to think about how can I craft an argument and use cases and language that I know are familiar to the judge. Because what Judge Seaborg likes to cite may be different than what Judge Coe likes to cite, or any other judge in the Northern District, and very different from what you see in the Southern District of California or in another court. So those are some of the things that are just going on today. That's scratching the surface just on litigation. If you have questions about transactional practice, we can talk about that too. But I also wanted to lay out a little bit of what comes next and how does this all fit together. So one of the data scientists on our team put this together not long ago, and I thought it was a helpful kind of framework for thinking about what technology is doing in practical ways. What kinds of questions is it helping lawyers deal with? So, for example, we've got description. How often is this motion granted? We're simply trying to look at past precedent and understand what happened within it. A next level up of complexity in some ways is about connection. So, which legal stories are connected? We, as part of our launch of company analytics, we ingested all of the news about companies. And we wanted to look at specifically legal news stories to knit them together with the underlying cases. So for example, you could look at Chipotle and see they have a series of lawsuits around employment terms, or a class action around employment and hiring practices. And there might be news stories scattered across 2 or 3 years talking about different stages of that litigation as it unfolds. And so we've done some work to knit those stories together and connect them with the underlying legal filings. So trying to help people make sense of lots of information in a way that tells a story. A third level in this kind of stair step is spotting similarities and spotting anomalies. So in the judge example, right, that means finding cases that this judge thinks is very persuasive. Or the flip side would be finding things that they use or cite that are anomalous. And those can be the same thing sometimes, but looking for the wrinkles that make judges unique or that make a given legal scenario unique. One of the things that I've always been kind of struggling with as we talk with lawyers is grappling with what I think is an existing mentality, which is every case is a snowflake. Every case is really unique. It's never been seen before. It'll never be seen again because the facts are different. And that's true to a certain degree, but I think it misses the broader point, which is that these cases are not all deeply, deeply unique. They do have unique facts. They have unique fact patterns, and the facts matter. But when you take one step back and you say this case is similar to a lot of other cases, what can we infer from what's happened in those other cases? Because there clearly is a pattern or a trend. Then what do we do in this particular case to change the odds in some meaningful way? So spotting similarities, spotting patterns is really important, I think, in thinking strategically about legal research and thinking about what's likely to happen in a given case. So you can step back from thinking everything's unique and not forecastable at all to say, okay, what are the examples that I can use that help me make a better data-driven decision? A fourth level up is thinking about explanation. How can we use technology to explain what you're looking at, not just provide you with information? So here, that might be thinking about how is a discretionary standard applied, and what are the differences between judges, and what explains that. So a standard might have multiple parts. Can we help highlight to you the part that seems to really drive the decision? Moving beyond just, this is what happened, but here's why it happens, because we know with extra detail kind of the combination of things that lead to that result. And lastly, this is a really interesting area to me, is forecasting. So how likely is something to happen? And it's a bit of a conceptual leap from the other side of the spectrum, which is description, right? So we could say, we've looked at everything this judge has done, and we've quantified it, so we know how often in the past they've ruled in a particular way on a particular issue. But it's a little bit of a leap to say that forecast what's likely to happen in the future. Oftentimes you can do that, and you can do that without problem, but sometimes you'll encounter a judge who hasn't dealt with a decision before, or a judge who's new, for example. So there's scenarios where you can't just go from historical data to make an inference about what's likely to happen next, but there's ways that we can build that forecast for you, even without specific data about a judge. So for example, if you were trying to forecast what a judge might do and they've never handled something before, you might look at similar judges. You might look at what the jurisdiction as a whole has done. You might look at the national average. And those would be better kind of priors to inform what you think is likely to happen than just guessing or saying you can't possibly know. And so when we combine those things together and have a better understanding of what drives the decision, we get better tools for forecasting. And that opens up a lot of interesting possibilities. So one of the rules of thumb that I think is helpful as you consider what is actually realistic today, and as you look around, not just the technology that you use in legal research, but the technology you use anywhere, in any of the apps that you use, any of the websites that you use, is what can technology and machine learning actually do today? And so I think this is a pretty helpful guide. It's from Andrew Ng, who's been a researcher at Stanford. He's worked at various companies like Google and Baidu. He says if a typical person can do a mental task in 1 second or less, we can probably automate it using AI now or in the future. And so any of the things that you use that feel a little bit magical, whether that's talking to Siri or translating something, are composed of little building blocks. It's not one kind of massive magical moment, it's sort of little building blocks that have been deconstructed essentially into little tasks that each take 1 second. And those building blocks have been able to be solved by using machine learning and then combined to create this end result that feels a little bit surprisingly good. So in the legal world, that could mean, to just keep going with the example that I've been giving around litigation, being able to look at a document and understand what the outcome was, who won, who lost. Being able to look at a contract and see, is this section about a particular clause, and what's that clause about? Being able to look at a clause and say, what's the key kind of thing within it? So you might say, this is a clause about governing law, and then being able to spot, well, what jurisdiction is actually saying is the governing law. So those are kind of the types of examples of 1 second tasks that a human could do, that when you build them up as Lego blocks, you have products that can then say, we can look across all of the contracts that this company has and help them spot risk by understanding which contracts are expiring soon, which contracts are out of the norm. Same thing with litigation. As I put together this slide, I changed the title. The title had previously been, Will AI Replace Lawyers? And that's not the most helpful title, but it's something that's been a topic over the last few years. I think the more interesting question is really, how will technology change legal practice? And so this is a look at a typical lawyer's day, more of a litigator's day, put together by McKinsey, looking at how their time is spent. So you could say from here, 44% of the time advising, communicating, negotiating, really human-centric tasks that are lower in their susceptibility to automation. But then a third of their time is spent doing research and analysis. That's obviously the chunk that my company tried to tackle, think about how could we build tools to help you research and make analytical decisions faster. There's a significant bucket around writing and drafting, and there's definitely a lot of new development going on around how can tools help you jumpstart your writing process, whether that's a motion or a contract or some standard form or agreement. And then some of these smaller buckets like doc review and case administration. So legal technology is going to play a role in many of these areas, and there's different products in each of these buckets of work. And as these buckets shift, I think it's an interesting question to consider what will then happen. So will new tools in the research space mean that you spend less time doing research, or that in the same amount of time you cover more ground? And I don't know the answer to that, but I think right now it probably means you cover more ground. So you might spend the same amount of time doing legal research, but at the end of that chunk of time, you've got better, more detailed answers. You've discovered not just the cases that are relevant, but you've figured out ways to use bits and pieces of them more persuasively, and you have insights about what's likely to happen after you make your argument. This is my last slide, and I guess maybe food for thought too. So this is research that Lexis had commissioned, trying to put some numbers on automation and different legal roles in the ecosystem. And so looking at the next 10 plus years, in these different roles, this is their conclusion, which was that with partners you might see about a 7% decrease in total work from automation replacing about 7% of their work. Associates 13%, paralegals almost a quarter, more than a quarter, and overall about 14% of work might be automated with tools over the next 10 years. But as this sort of subtitle hints at, it's not necessarily clear that that means less work overall. It means maybe there's some shifting going on between the types of tasks that you do. And so that hopefully means kind of a more interesting future for legal practice, I think. Generally, the things that we can automate today are not that exciting or satisfying, or probably the things that you went to law school in the first place to do. So hopefully that opens up the ability for lawyers to spend more satisfying time doing things that only humans are really great at: analysis, strategy, thinking creatively. So I'll stop with that and turn it over to questions. Yeah.
So I'm going to ask you to do a little bit of forecasting here.
Okay.
I'm interested in the judicial analytics, and I'm curious how soon, or maybe already, do you think that these analytics begin to affect the more political context that judges are in, whether it's a confirmation hearing or an election for a state judge? And then related to that point, how do you anticipate judges responding to the analytics in sort of a feedback loop? Are they going to be concerned about their motion grant rate, as almost like an Uber driver is concerned about their 5-star rating, divorced from the facts? I'm just kind of curious how you envision these playing out.
Yeah, it's a great question. I don't have all the answers. So I think what we've seen is that judges are still developing awareness that these tools exist in the first place, and they're still surprised at the variation that we can show them between them and their colleagues. So when Judge Seaborg learns that he grants a particular motion 60% of the time and his colleague Judge Orrick grants it 70% of the time, he wants to pick up the phone and have a conversation with Orrick to figure out why are we doing these things differently. We've tried to do some deeper analysis to figure out so as we've experimented with forecasting, we've looked at a range of factors, sort of everything that we could get our hands on to see what determined why Seaborg's at 60% and Orrick's at 70%. And we didn't uncover political bias being one of those things. So we didn't discover that the party that appointed the judge was a relevant factor in determining how likely they were to do something on a motion to dismiss. Doesn't mean that that's not a relevant factor, but for a lot of parts of legal practice, I don't think there's going to be a clear political bias that will show up in something meaningful like an appointment confirmation hearing. But I don't know. These things can be a little bit unpredictable. At the other end of the spectrum, in France, they've banned judicial analytics within the last 2 years or so. And their reasoning is not super sound, I don't think, but they essentially said, judges are actors of the state, They speak on behalf of the state, and they're not individuals per se, so it's not important to know what they do as individuals. Therefore, analyzing their decisions and attributing things to them individually is not allowed. Which I think sort of just puts your head in the sand. It says, if we don't know that they're different, then they will not be different. But the truth is that those judges are still making decisions differently, and now the French just will be less aware of it. I think there's implications about whether it's good or bad for the legal system and how people perceive it to be fair or not. And it's a conversation I was just having with David Engstrom, actually. So if you want to continue this conversation in the Stanford ecosystem, he seems to be the guy who's thinking about this stuff. But all that stuff is yet to play out. It's still pretty early. I think where you might see it most kind of saliently is in the criminal space, with things like bail and sentencing. Unfortunately, analytics are a little bit lagging in that space just because it's not where the money is from a company perspective. But there will be greater insights over time with how judges vary in criminal practice. And I think that is probably a higher profile, kind of more tangible thing that people can wrap their heads around. Yeah.
As a follow-up to his question, I think I heard you say that you've determined that the political party for appointing judge wasn't relevant in determining the data that you showed. About how many variables were in that data set? How many other things you could look at? Was it 50, 500, 5,000?
Yeah, it was dozens and dozens, so somewhere more than 50, I think, and somewhere less than 500. But what we did identify as being relevant, at least in ways that we could measure and toggle, were things like, to take a motion to dismiss, the type of asserted defense mattered greatly. So whether it was a 12b6 or a 12b5 mattered a lot. Whether one or both sides were represented by a big law firm mattered. And you can imagine which side it mattered. So if you had the big side on your side, you were more likely to win if the other side didn't. The practice area matters, so what kind of case it was. Jurisdiction matters, of course. So those were some of the relevant factors that definitely started to be statistically significant in figuring out what was likely to happen. And so again, I'd reiterate, I can't say that for all types of decisions, the political kind of inclinations don't matter, but in the things that we were looking at specific motions at the district court level, we couldn't see a bias.
We have a question from someone online. How mature is this legal informatics area, and how many years of research work we anticipate till legal informatics gets saturated?
Well, it's pretty mature, but it's still early. So, my company started in 2012. We launched these analytics in 2015. LexisNexis had done something similar on a similar timeline. And we were really the first two companies that were showing you statistics about how judges rule. So that's within the last 5 years. There is now analytical products, obviously within Lexis, within Westlaw, within Bloomberg Law. So you really can't go online now and do legal research without some exposure to analytics, which I think is great. But you'll also notice that analytics in each of these platforms is a little bit different depending on which data set they're looking at and how they're classifying things. So there's probably some convergence that happens over the next several years. But right now it's pretty mature. There's a lot of data, but it's also early stages. So like I touched on, there's some extra levels of insight and granularity that we're going to get to over the next 5 to 10 years that give you a lot more depth and richness to thinking about what's likely to happen in a given transaction or a given lawsuit. So I think it's still pretty early stages. There's still a lot of attorneys who don't know that these tools exist. Lexis has been running studies, surveys for the last couple of years just to understand awareness. And I think it's just this year where it crossed over a threshold of more than 50% of attorneys even knowing that legal analytics exists in the first place. So change is a little bit slow in the legal space, but it's definitely happening. And I think I wouldn't say it's accelerating per se, but there's going to be a lot of activity over the next 5 years.
To what extent do you think that the predictive models are fitted more for common law systems, meaning because they based on the precedent, the value of precedent in common law as opposed to civil law?
Well, there's been there's not been a lot in civil law jurisdictions so far. Most of the innovation in the legal space seems to be happening in the US still. And we regularly kind of hear from folks in other countries that the US is 5 to 10 years ahead of technology that they're seeing elsewhere. So I think folks are starting to grapple with it and figure out what do analytics look like in a civil law setting. And maybe that's not the right question. Maybe it's sort of like, what are the other technologies that do make sense in the civil law space? But it's definitely, the common law is a really interesting web. It's a really interesting network because you have judges telling you what they think, and it evolves and changes. And so when we do analysis of that for creating a visualization for search, right? So a search engine in the law is similar to how Google it operates, which is essentially off of a page rank system. So Google, if you're not familiar, will rank a website in large part based on what other websites link to that website. That's how they determine which websites are most valuable or not. And that's a really good metric for thinking about legal research too, right? You want to use cases that have been cited by other cases. And the problem that Google has is that websites can create spammy links and create link fraud and kind of have a lot of noise that's designed to fake out the system. In the law, you don't have that. In the law, you have judges citing other cases. There's no spam, so it's a really clean network to tell you which cases are most important. So I think that's among many reasons why the common law is really interesting, but you also have just massive volumes in the US. It's a big industry, it's worth a lot. There's a lot of practitioners. The only other market I'm familiar with that is close in the terms of actual attorneys is Brazil. But most other places have a limitation either on the volume of data, the accessibility of the data, the number of practitioners that make it difficult for technologies to translate across borders too.
So I know this wasn't absolutely focused your remarks, by the way. Thank you for all of those on legal analytics. I'm curious from the business side how you thought about making sure your business gets valued. If you've looked into intellectual property, and to what degree Westlaw could just build the same features you've already spent all these years building, and just say have its own analytics platform.
Yeah, so we filed for patents early on. We had a couple that went on their way through the system and ultimately were not granted, and it wasn't that important to us by the time that happened. We always figured that some of what we were doing was common sense and not truly patentable, but nobody had done it before. But the other thing that we felt was that we would be moving faster than our competitors. So as soon as Westlaw caught up, we would be doing something differently. And that played out to be true. As you guys probably know better than I, but software patents are pretty difficult to get today. And so it's not necessarily a core part of how we try to build a defensible business of patenting things in particular. But we did keep trade secrets, so a lot of how you do machine learning is pretty defensible and secret sauce in that it requires lots of training data, it requires experience, it requires good combinations of data scientists and lawyers working together. So all of that felt defensible in a more kind of practical way than the patent system protected us.
More online questions. So one is, what statistical analyses does the data lend itself to, e.g. distributions, hypothesis testing, etc.?
I don't know. That's a good question. I think the jury's still out. There's a new field called empirical legal analysis, where there's a variety of interesting practitioners looking at a bunch of different facets of legal decision making, everything from criminal to civil. I sort of leave it to that group to figure out the questions that they want to ask. But there are now data sets available that make this sort of research more possible than it ever was. So as part of our work at Ravel, one of our theses as a business was that legal information was becoming more available, and it was being released by the states and by the federal government in a way that allowed us to catch up to Lexis and Westlaw, who otherwise were not making cases generally available because they've been difficult to collect and expensive to collect. So that was our thesis. Turned out we were too early. It's still not generally easy to collect case law from states and from the federal government. And so it's very difficult to put together a comprehensive collection So we ended up partnering with Harvard Law School, which had virtually only physical collection of every case from every jurisdiction going back to the beginning of the country, aside from the Library of Congress. So we digitized that collection with Harvard. It cost us a lot of money. They did it on site, but we ended up with this authoritative collection of every single case. And we've made that collection available online for free through ravellaw.com, but also through Harvard websites. And we've made bulk access to it where people can pull down massive or full kind of encapsulations of the collection for research purposes. So if you're considering doing research in this space and you want access to a case law data set, there's a mechanism through us and through Harvard where you can make a request and get the bulk collection. So I'd encourage you to check that out.
So the law is pretty complicated, but so is data science. How did you kind of make that jump, and how does your data scientists and data analysts work with the lawyers to make sure that they're developing and they're finding the correct insights? Like, do you prescribe, like, I want to find political bias, go? Or is it more like, what do you see?
Yeah, so it might be helpful just to walk through a quick example. So one of the things that we solve with machine learning is identifying whether a case deals with a particular motion. And so when a case goes through our data systems, we hit it with a couple dozen different machine learning algorithms. So each algorithm is designed to do one thing. So that might be identify the judge that wrote it. It might be classify the case and say whether it's a patent case or an employment case. Another algorithm will be designed to identify, does it deal with a particular motion? Another one will say what happened with that motion, was it granted or denied? And so each of those algorithms is trained in general using a combination of human sort of legal and data science expertise. So what we'll do when we're trying to identify motions, for example, is put together a training set where we have a team of lawyers and trained annotators go through a big collection and mark up by hand, saying this case deals with this motion and this was the outcome. So we have this kind of ground truth that we then train an algorithm to work from and say, okay, we're going to compare how that algorithm does against our humans on some new cases that the algorithm hasn't seen before. And that way we can measure how well it's doing. And it's generally not about getting to 100%, but it's about getting to 80, 90, 95% accuracy, where 95% of the time it's going to spot the right motion and classify it accurately. And so that conversation between what the lawyers are looking at and using to recognize something is a conversation that's had with the data science team and with the annotators who are doing the actual work to figure out how do we kind of extract and learn from this document in a way that uses the knowledge of what a human can look at and then kind of uses that to inform an algorithm. So ultimately there's not necessarily a lot of legal judgment that has to go into that, but we have lawyers at the core of the process to help make decisions about the nuances and the edge cases, because there can be some complexity.
How do you think that legal education in law schools or legal training in law firms should react to the growing use of AI and data analytics? Some people have said that it's important for young lawyers to understand also the mechanics of the research or producing certain documents, and with all this AI and automation, they might not actually understand what goes into producing a specific legal service. What's your take on that?
So when I started Ravel, I didn't have a software background, and so I couldn't code the first thing about what we needed to build. And as I talked with folks, I got differing, conflicting pieces of advice. Some people said you should go learn how to code and build it yourself, and other folks said, spend your time building a team and finding people who have the skill set. So I took that pathway. I still can't code today. But what I did get good at was building a team and finding folks who could get fired up about the mission that we were tackling and who could explain what they were doing in a technical way to me as a more non-technical person. So over the years, I've developed a familiarity and understanding of our processes and how we do things. And my thinking at the time was, I'm invested in law school, I'm developing expertise about how to be a lawyer. There are folks who've been spending an equal, if not greater amount of time learning how to code. it would be a race I would never win to try to switch gears and learn how to code at a level that somebody who's really dedicated their time and energy to that. So it felt like a way better use of my time to develop the other skills around building a team and understanding how to have a conversation. I generally translate that to how I think the tools needed today are. I think for some people it can be an interesting exercise to learn how to code. I don't think it's necessary to be a highly functioning attorney today. I don't think you need to be able to like code your own software or understand exactly how an e-discovery program works or understand exactly how these legal analytics are created. I think being conversant in general with the possibilities of what technology can do can help you be more creative and can help you think about kind of broader transformations that the legal industry is still ripe for in terms of how law is practiced in the business of law. But I would sort of get into that only if you're deeply interested in the business of law. For the practice of law, I still think your time's probably better spent being a legal expert. That said, I do think there's still a pretty big gap between people taking advantage of analytics and how they think about legal strategy today. So when I was taking civil procedure, we never talked about how likely a motion to dismiss was to be granted. We never talked about, we learned how to write a motion for injunctive relief, but we never learned that they're granted only 25% of the time. That was sort of talked about around the edges of this is difficult to get and the standards constructed in that way, but nobody could really quantify how difficult. And I think that having that information at your fingertips is really powerful in thinking about making decisions that are not just based on anecdotes or hunches. And I know that this is still percolating its way through practice because you can go to partners today and say, imagine a client came to you with this kind of case and this kind of motion and asked you what was likely to happen. And this happens all the time, right? Partners and attorneys are constantly confronted with questions from clients saying, what's likely to happen? And the partner might say, well, I think based on what I know, it would be 10% of the time this motion will be granted. We can say, well, we can actually answer that question now with a couple clicks, so let's go see. Turns out the motion is going to be granted 40% of the time or 50% of the time. And so experts, even partners, are making decisions based on hunches that are not good data, which just speaks to the fact that this is a space where I think there's an inclination to treat cases as snowflakes rather than to look for some underlying statistic or kind of valid prior that can inform a better, kind of more data-driven decision.
So a few questions from online. I'll lump a couple together. So one is, do you see a business model feasible to get this information to solos or small law firms? And then what is the pricing for the product? What % of market penetration do you think products like Ravel Law will achieve in the next 3 years?
Wow. Detail. I'm not going to speak to pricing. It varies based on what size firm you are and all that. But these things are very accessible to small practitioners. They're just software, so there's no extra cost in having to order a print copy. They're as accessible to somebody who's practicing solo as somebody who's at a big firm, which I think is pretty neat. Market penetration, I know that within Lexis, our products have been growing really well. They are used now by hundreds of firms, thousands of attorneys. Awareness is growing, as I mentioned, in these surveys that Lexis conducts regularly. And more broadly, given that Lexis and Westlaw and Bloomberg, if anybody uses Bloomberg, all have analytical offerings, I think adoption is going to grow very quickly over the next few years. So that to me is the more holistic answer, which is I'm not so concerned about our specific product. I think there's a big kind of rising tide of analytics that's going to make them much more common and much more necessary as a part of the process of legal research than they have been.
As a business owner, what are some mistakes or missteps you've seen from other competitors, even trial and error that you've seen? Because with technology, as we've discussed, it's a new industry, but what are some of the unique challenges that you face as a business owner?
Well, the legal space has seen a lot of innovation. There's a lot of companies, a lot of startups in a lot of different corners of it. Everything from research to case management, e-discovery, et cetera. One of the things that, there's a lot of ways to answer that question. One of the interesting ones, though, to me is that not all not all of those niches of legal practice are venture-backable businesses. And so a venture-backable business is a business that could, you know, if you squint at it, be $1 billion business in a 10-year period, which means, you know, getting to like $100 million in revenue. And there's not so many parts of the legal space that are possible to generate $100 million in. So I think there's a lot of companies that they don't properly size the market. They say, I'm an attorney, I struggled with this problem, I'm going to start a company, and they don't take one step back and say, what kind of company will that be? Because there's a variety of different companies. There's companies that you might fund with your own money, there's companies you can fund with friends and family, there's companies that you might get up and running and they kind of plateau at $5 million a year, which is great if that's the kind of business you want to run. And there's companies that a venture investor will back and that you can then go on and raise more and more money as you try to build a big company. So I think just like taking an honest view of the niches of the legal space and accurately assessing how big is the market there is one of the challenges that folks in the space seem to have.
Yeah, can you take me through your thought process on how you think about the cost of being wrong in legal analytics? And things specifically like whenever you have machine learning, you're going to have some false positive error rate, right? And in certain, let's say in criminal justice where you're assigning bail or like predicting recidivism, the cost of that is very clear. Yeah, how does that work, especially in the civil justice space?
Yeah, it's a really good question. So with things like motion analytics, right, we know that we're not 100% accurate. And what we advise folks to do is to look for sample sizes that are big enough where those errors sort of come out in the wash. So if you're looking at a judge and there's only 3 decisions, if you're just looking at the number and you're not actually reading the cases, if we got one of those things wrong, you'd be off by a big margin. You wouldn't want to make kind of bet the company decisions on that. But if you're looking at a judge and there's 60 examples of something and you don't want to take the time to read through all 60, and you can say, I don't want to trust the system to tell me on average, like roughly 60% of the time this happened. That's a really good use case. So as these systems get better, I think you'll be able to get more and more granular and they'll be more trustworthy for smaller sample sizes. But again, I think there's just like a simple logic of you're not going to make big decisions based on small sample sizes, even if the sample sizes are entirely accurate. So the other way that we approach this is trying to be really transparent with the underlying information. So if we put a case in front of you and say this, we've identified that this case deals with this motion and this is the outcome, we're actually going to show you the language that we've identified. And you can then quickly assess whether we got it right or got it wrong. So I think that's a pretty useful technique in just being transparent with how the system is, what it's looking at to tell you something. It's not necessarily feasible in every part of a product, but it's possible in certain places. The criminal space is much more sensitive, obviously, and one of the challenges there is that sometimes courts will contract with a private company to create an algorithm for determining bail or sentencing, and then that algorithm will be kind of hidden and unviewable to the general public, kind of hidden behind the guise of being proprietary. And I think that's just totally unacceptable. So particularly when you're dealing with issues of criminal justice, and when courts are relying on this sort of outside standard setter. So we haven't confronted that in the civil space, but in the criminal space, that's a huge issue.
Do you anticipate these analytic tools being moved to administrative litigation? And if so, what kind of adaptation do you think? Because decision makers would be quite different from judges.
Yeah, it's not a space that I know that well, but David Engstrom has studied this. So he had a group that I think issued a report recently looking at machine learning being used by agencies. And I don't know what they found, I don't know what they concluded, but that might be something you check out.
So some of the online questions, I think there was one about NLP accuracy that was kind of related to the one that was just asked. Someone else says, do you see the position of data scientists being a common position in law firms of the future?
Maybe. Law firms today, there's definitely some that are starting to hire folks who are data scientists or chief information officers. There's some firms that are doing more interesting things than others. It's still not all that widespread, and law firms are, in their current construction, not necessarily great vehicles to do R&D. They don't take a long-term perspective on investing in software development. They generally don't have any way to commercialize something that they've built, so they have to build something that only works for them, which means that, again, you're sort of naturally constricted by how much you're willing to invest in building something because your market size is very small. So there's some pretty big challenges of law firms trying to develop their own technology. And that's not a reason to say that they shouldn't have data scientists on board, but they need to think about a deeper reconstruction of what a law firm looks like for, I think, capturing the most value out of investing in software development. So that's a world that I'm excited about, but there are regulatory limitations at the moment around how law firms are constructed and who they can share profits with. And I hope that stuff changes. And there is some change underfoot, but I hope that changes pretty quickly because you could see a lot of interesting evolution in law firm structures.
All right, you mentioned good data. And how fast can you realize that you're working with right and not biased data, if not biased data even exists? What do you think?
Well, so training data, right, is one of these areas that you may read about in not just the legal space, but anything, facial recognition, image recognition. These are areas where having a representative training set is super critical. So what I mean by that is if you're training a facial recognition system and you train it just with faces from the Stanford community, you're not going to represent the full spectrum of human faces. And so you're going to have a system that's going to make misclassifications. In the legal space and in the work that we've done, we don't have to grapple exactly with that same question and the nuances of it. So when we're looking at cases, for example, we can get representative samples of cases. We don't necessarily have challenges of like training using the wrong data. But with things like criminal sentencing algorithms and bail algorithms, those questions are really sensitive. And it's an interesting space of research. So getting the kind of an accurate set of training data is an important question, but it varies. Like the implications of getting it wrong vary depending on the space that you're in.
What do you think from your perspective as VP of product? What do you think are the most exciting opportunity areas to find new use cases, build new businesses using AI in a legal setting?
Yeah, I think there's a few that are really interesting. So one area that's booming right now is contract analytics, trying to take the similar approaches that we've developed for litigation and apply it to agreements and contracts so that companies or law firms could quickly parse through a big set of agreements and understand what's contained within them. That market is super healthy. There's a lot of companies competing in it now. And it's an interesting application of kind of known technology to these other use cases. A second frontier that I'm interested in is forecasting and saying how do we go look ahead on cases to understand what's likely to happen. And to me, there's a really interesting intersection with litigation finance, which, if you're not familiar, is a space that's been rapidly growing. It's now a multi-billion-dollar industry. It's kind of like private equity, where they will invest in lawsuits to essentially share in the benefits, but also offload the risk from a law firm or a plaintiff or a defendant that has that litigation. And as you might imagine, litigation finance is based all around what's likely to happen with a given lawsuit. They don't want to make an investment if they don't know kind of probabilistically what's likely to happen. And so right now, that space is really working at the high end. It's working on cases where there's big judgment values and kind of surefire outcomes, where they can feel really confident that they know with a pretty high level of certainty what would happen if it went to a jury. And they're operating at that part of the market because they're doing it with human judgment. They hire experienced attorneys and litigators to come in and evaluate cases and make these decisions. So it's a manual, human-centric process. But as we have analytics that help you look more granularly at cases, you could imagine litigation finance starting to expand what it can do. You start to cost effectively value lower value cases and spread investment down that part of the spectrum. I'm not saying that's a good thing or a bad thing, but it's definitely one of the things that might happen as we move into the space of kind of more granular analytics and forecasting. A third thing that I think is really interesting is taking the next step into writing and drafting. And there's some interesting tools that are starting to develop around automating a drafting process, whether that's responding to a complaint, jump-starting a contract with kind of standard clauses, jump-starting motions. And I think combining that with analytics about what's market, kind of this is a standard and here's why we know it's a standard and here are variations that are acceptable, that are commonly used. Those are interesting ways to think about how do you practice effectively and in a data-driven way.
Just as a follow-up question, so what's your prediction? Will the market need more of your lawyers in the future?
I don't really have an expert opinion on it. Yeah. I've got two brothers who are attorneys. I've got two parents who are attorneys. So I'm not in the business of putting attorneys out of work. I think the legal market seems pretty healthy to me. It feels to me like there's actually a lot of unmet demand. And it wouldn't surprise me at all if there's room for the legal market to grow. I think there's a pretty big gap actually between unmet legal needs at the low end of people needing legal help that can't be served profitably today by the existing cost structures of the legal industry. So there's a lot that goes into that, and we could spend a whole day unpacking it, but I think there's a plenty of unmet legal need that if we had better tools, better automation capabilities, there's ways to tap that, serve more people. At the high end of the market, at like the sort of company law side of the market, I don't know what's going to happen, but it seems like things are pretty stable today. Firms are growing, and without major regulatory change, I guess the long way to answer your question is I think the regulatory change piece of how law firms and the business of law are constructed would drive a lot more change in employment than what we're talking about with technology. The technology change will be relatively gradual.
If you were working on one of these automation technologies, whether around contract drafting or policies and procedures, that kind of thing, right now it's very much brute force, copy paste, somebody finds a template, etc. How would you go about validating and sizing the market given that so many attorneys are reluctant to change? Like it's a hard discussion to have with attorneys because they're used to sending it to the paralegal or just doing it themselves the old way. So how do you think about that?
Yeah, I mean, there's the standard way would be to look at if you're creating a product, how many people are in that target market, even if you think that a vast majority of them are difficult to change. But you'd still say total addressable market is everybody who has this problem that I could potentially serve. And then the challenge is more of a product one and a marketing and a sales challenge of like how do you overcome that inertia. And so, one standard kind of rule of thumb in the startup space is that to get folks to change from an existing system, even if they're super unhappy with it, you need to be 10 times better. That could be 10 times faster, 10 times cheaper, but that order of magnitude to really motivate change, which I think speaks to the challenge of any industry. That's not a legal industry rule of thumb. That's just kind of in general getting folks to change is difficult work. But I think you start from total addressable market, who are all the potential users. Some percentage of that is going to be quick movers. They're going to be early adopters, say 10%, 15%, and then so you get those, and then you have to figure out how do you make the leap to the more kind of intransigent users.
So someone online is asking for your take on legal tech products like IBM Watson.
What legal tech product by IBM Watson? IBM Watson, if you're not familiar, has run a big marketing campaign that says they've got this technology that'll answer questions, and they I think got a little bit out of their ski tips in terms of marketing matching reality. I'm not saying that there's not valuable use cases for what they've built. I haven't seen anything in particular in the legal space that's powered by Watson that's doing incredible things. And in general, I caution folks to, not just with IBM, but look skeptically at all of the marketing claims around AI and machine learning today. In general, I think there's a tendency to overhype what's possible. Hopefully what I pointed out today makes clear that there are some really specific things that are working well, and that there is a lot that's feasible today. But in some ways, like the marketing is going to create collateral damage around people being disappointed by what was promised and then under-delivered.
Just one more. Can you maybe also just spend just a minute to talk about your own sort of career path as, you know, someone as the one black sheep in your family who didn't become a practicing lawyer, but still have formal best legal training from this law school, and then becoming an entrepreneur, now working for, you know, a big Fortune 500 company. Is that sort of, you know, is that sort of a career path that will become more common? Is that something that, you know, that's an option for other law students? How do you feel about that?
Yeah, it's from my class, there are 3 other classmates who are also employed by Lexis, which is really weird. So there's my co-founder, and there's 2 folks who are at Matchmaking. So, you know, 4 people out of a class of 180 ended up at Lexis through startups that got acquired. That's an anomaly for sure. But there was a cohort of folks in my class who ended up doing startups either directly or joining them early. And I've seen a bunch of folks, after doing a few years at large law firms, migrate into corporate practices that are much more kind of product-y. So I think it's a really interesting pathway. I would highly recommend it to anybody. And it's very doable, particularly from Stanford. And I can't say that at every school that I speak at. But Stanford is really a unique ecosystem that has resources that put you at an incredible advantage if you want to go down this pathway. There's the ability to take classes at the GSB. There's the ability to take classes at the D.school. There's business building competitions. There's advisors. There's teachers who are super plugged into the ecosystem. There are classmates studying computer science within 5 minutes. There's your email address, which will basically get your email read by anybody you send an email to. Honestly, like if you send somebody an email from stanford.edu, like it will get opened and read, and you will get a response. Not everybody has that. That's like an incredible tool. So I would really encourage you to take advantage of the resources that you have while you are here. You may feel busy, but if you have a passion to explore something outside of the traditional coursework, take advantage of the time that you have. For me, I found myself, like I said, I was not interested in legal technology when I came into law school, but I found it to be this problem that became more and more interesting, and I spent nights and weekends on it. And it was enjoyable to go check out the CS courses and see their demo days, and to go hunt down a computer science professor and then read an interesting paper, meet folks like Roland who could connect me with folks in the system who had already gone down the path and could be mentors. So somehow my co-founder and I were able to do all that during the normal course of Stanford and be able to take some classes that gave us credit to do it along the way. So it's definitely possible. It's fun. It's a fun journey. And I would recommend it.
All right, well, on that note, if there are no further questions, please join me in thanking our speaker today. Thank you.